case number 2019-CR1402, captioned State of Kansas versus Victor Rentaria. Would the parties announce their appearances, please?
May it please the court, for the state, Assistant District Attorney Viet-Le.
May it please the court, the defendant appears by Zoom, and his counsel appears by Zoom as well.
All right.
Oops.
We are here set down for a sentencing today. The record should reflect that the parties appeared in court on June 18th, at which time the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted, ordered a pre-sentence investigation, and set it for hearing today. I've received that PSI. The critical findings are as follows. The sole count of conviction is one of attempted robbery. That is a severity level 7 person felony. The defendant's criminal history score was found to be that of B, as in boy. That would leave him with a presumption of prison and a presumed underlying sentence of 27, 29, or 31 months. He would be, if he has to do that time, he would be eligible for up to 20% good time credit and subject to 12 months of post-release supervision. Special rule number 9 applies to this case in that the defendant was on parole at the date of the offense. If he was to be granted probation today, it would be for a period of 24 months to community corrections. Mr. Le, I would ask you first, have you had an opportunity to review the PSI? Any additions, corrections, or challenges?
Yes, Judge, and I don't have any additions.
Thank you. Mr. Sedgwick, same question.
Yes, I have, and I do not have any challenges or additions at this time.
All right. Mr. Renteria, your lawyer is telling me that he went over this pre-sentence investigation report, specifically that criminal history score sheet in the back, and that you don't have any challenges. You think that it's accurate. Is that correct?
Yes, sir.
All right. Given that, I will adopt the findings of the PSI for today's hearing. Mr. Lett, I would hear any comments as to sentencing you might have.
No, Judge, I don't have any comments.
Mr. Sedgwick?
Your Honor, my client's accepted responsibility for this, and I found him a cooperative individual to work with. That's the only comments that I have.
All right. Mr. Renteria, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
Bush. Just asking for mercy. Yes, sir.
All righty. Thank you. Mr. Sedgwick, do you know any legal reason why I should not now proceed to sentencing?
No, Your Honor.
All right. Well, look, I think if I read the plea petition correctly, there wasn't any kind of agreement as to recommendations on sentencings, and I don't see a downward departure filed for it, nor do I believe in this case that it would be particularly persuasive to the court. I've reviewed the facts of the case, the plea as it was entered, and the defendant's criminal history. Specifically, I would note that this isn't the defendant's first time being involved in an aggravated robbery or an attempt thereto. And I do think that prison sentence is called for in this case. Therefore, the defendant will be sentenced to the standard range of 29 months in the Department of Corrections. I've considered probation, and I find that it is not appropriate in this case. So probation is denied. He will be entitled to up to 20% good time credit and subject to 12 months of post-release. I believe by operation of law that this case must run consecutively to the 2 cases on which Mr. Renteria is on parole, those being 2008 CR830 and 2011 CR493. If I'm mistaken in that they are required to by law, this court finds that it is appropriate to exercise its discretion to make it consecutive in this case. Mr. Lett, do you know if there's been any request for any kind of restitution?
Judge, we tried to contact the victim for restitution, and we have not heard back from the victim, so we have no verifiable restitution request.
All right. Then I'll find there's no request for restitution today. As far as the court costs go, I know that Mr. Renteria is employable when he's out, and that will be a condition of his parole. So I'm going to order the docket fees and the supervision fee. I am not going to order that become due and payable until he is released from custody. Mr. Sedgwick, do you know the amount of your attorney fees?
Your Honor, I apologize. I don't have it in front of me. I did email the voucher to you, I tried to earlier this morning. I think it's actually a substantial amount. I think it's closer to 1,400.
All right. Well, I'm only going to assess $100 of that plus the bids application fee, given the amount of requirements that the client is going to have when he is released. So I think I can cut him that break. All right. Mr. Renteria, you have 14 days from today to appeal anything you don't like about your sentence. You also may be able to seek expungement of this conviction after a period of time following successful completion of post-release supervision. As a convicted felon, it's prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. Do you understand all that?
Yes, sir.
All right. The defendant will be credited for jail time, credit for each day that he's been in prior to today's sentencing. Mr. Lay, I would ask you, do you know of anything that I have failed to cover today?
Judge, I might have missed it, but does the defendant have a duty to register under the Kansas
That's a good question. Remind me, was there a gun finding made at plea?
Your Honor, I do not believe there was.
Let me see what. Do you recall, it's not in the plea petition, Mr. Sedgwick, was the allegation of the gun brought up during the plea, whether or not they were taking the gun out, whether or not the factual basis given at the plea included the use of a firearm?
Your Honor, there was some alternatives, and it is my recollection. I hope I'm not and my memory isn't that great, but it is my understanding that there was discussion of whether there was a knife or a gun or a big stick, and that the court and that the district attorney had stated that they had not discussed making it part of the plea, so they were not going to put it in at that time.
All right. I think that's correct. If I remember the factual basis on this, there was at least some question as to whether a firearm is used. So this is not a registration offense. I'm not making the firearm finding for today. Thank you for that, Mr. Ladd. That was a good question. Anything else you can think of?
I see on one of the miscellaneous provisions, placement to ISP and court authorizing community corrections to access the confidential information of the defendant.
Yeah, I don't know what that is, and that it's not something I would make a finding on today, particularly since he's not being granted probation.
Yes, Judge.
All right, Mr. Sedgwick, anything you can think of?
No, Your Honor.
All right. Well, then I think that will do it for our hearing. Mr. Renteria, good luck to you. We are adjourned.